by answering those questions. So again, our training today is brought to you by our partners over at the Workforce Development Board of San Bernardino County. And today we are joined by Carmela Giliberto, Business Services Specialist, and Angelica Villaseñor, Business Services Representative, who are both here to share more about those resources available to employers like yourselves. Good morning, ladies.
Good morning.
Good morning. Thank you, Anna. Thank you, everyone from CEA for putting this workshop together. San Bernardino County Workforce Development Business Services is here to support your recruiting, hiring, and training needs. We have 3 America's Job Centers, one in Victorville, San Bernardino, and the other in Rancho Cucamonga. Available services to businesses in the County of San Bernardino. As you can see in our flyer, we have on-the-job training. You can receive up to 480 hours of reimbursement for training for new hires or existing employees. Employers may be reimbursed up to 50% of wages during the training period, including for incumbent workers who take on new responsibilities with wage increase. We also have employer recruitments and hiring events. Our team can coordinate customized recruitment events at your business or at one of our locations, managing marketing and logistics. Additionally, we host monthly hiring events across the county, connecting employers with an average of 200 to 250 job seekers. And Carmela Giliberto can talk to you about our incumbent worker training.
Thank you, Angelica and Anna. As a business service specialist, I work with business consultants who help businesses in need of funding for needed business improvements, such as incumbent worker training, as Angelica mentioned, social media marketing, leadership training, etc., to increase productivity and therefore prevent layoffs. We recently rolled out an exciting transitional job program. Think of it like a part-time paid internship where the county is the employer. And we will provide the business with candidates for your consideration for up to 320 hours at no cost to you. It's a win-win, as you get additional help while giving our unemployed job seekers the opportunity to gain work experience. Want to save money? Take advantage of our complimentary HR hotline. As you see here, 1-877-282-3763. We also have an employer toolkit where you can have access to various resources as well as links to all our partners in San Bernardino County. And please save our website, workforce.sbcounty.gov, to access our calendar of future events. If you're interested in any of these services, I'll put my information in the chat. Reach out to me so we can set up an appointment to discuss them in further detail at your convenience and customize them to your needs. Thank you so much for your time and patience with this little snafu we had this morning. But believe me, it's all worth it because it's going to be lots of fabulous information brought to you by our fabulous speakers here, Juliana and Eliseo. Make it a great day.
Awesome. Thank you again, Carmela and Angelica and your entire team for everything that you do for San Bernardino employers and beyond. So now, without further ado, I'd love to introduce our trainers today. We have Juliana Gabriel, our Senior HR Compliance Director, and Eli Nunez, our HR Director, who you may have had the pleasure of working with either one of them on that HR hotline. They'll be leading us today's session, so you're in great hands. And Eli, it's all yours.
Thank you very much, Anna, Angelica, Carmela. Very, always nice to partner with San Bernardino. You guys do a great job, and we have a lot of good information for you. A little bit more about us. We are California Employers Association, and our goal is to provide you with peace of mind, whether it's on that complimentary hotline you called us on or with training such as this. We try to bring you up-to-date information to help you with your HR needs. We know HR is very complicated, especially here in California. So we do our best to kind of ease that burden for you. So we provide training such as the one you're on today. That some advice on that 800 call or hotline. So if you want to call, talk about an issue, have a question, or just talk through a situation, we're there for you. And there's almost nothing we haven't heard about. We work with a lot of different members in different industries, whether it's, restaurant, food production, manufacturing, construction, different counties all over the place, whatever it is. Give us a call and try to stump us with your questions. Same thing goes with this presentation today. If there's anything that you want to hear more about, you have some more questions or something that's very individualized to your business or your situation, please give us a call and we could talk through it as well. Having said that, we do provide a lot of information, but one thing we do not provide is legal advice. We are not attorneys, or we don't, and even though there are some people on our team with legal training, we are not your attorney. So what that means is everything that we present or give to you should be taken from an educational perspective. We give you the tools, background, ideas. We let you know what the laws and guidelines say, but we do not provide legal advice. So with that, let's jump right into our presentation today. We'll talk a little bit about wage and hour updates, some leaves of absence and benefits changes, employee rights, what has changed on that front, whether it's with new laws or new cases that have come about. We're going to talk about artificial intelligence. Seems like that's everywhere, all over the news, whether it's new companies rolling out, new data centers, whatever it is. We're going to talk about what artificial intelligence is doing to the workplace and things you can prepare for, along with some laws relating to it, as well as Juliana will cover some case law and regulations and how those are changing the landscape in California. So to start, let's talk about a little bit about wage and hour and your payroll, some changes for 2026 that we're seeing. Of course, we're seeing some increases in wages. There have been some amendments to the Equal Pay Act. If you were with our labor law update, I believe it was last year or in previous years, we talked about a lot about the Equal Pay Act and what that meant to employers. So we're going to talk about some amendments and some changes for 2026. And we are going to talk about the OBA, or One Big Beautiful Bill Act. A lot of the news and chatter around that revolved around qualified tips and overtime. No tax on tips, no tax on overtimes. That's all we heard. Well, we're going to break down what that really means to both you as employers and to your employees. On a limited basis, of course. This isn't an accounting or payroll webinar, but we're going to cover the basics of this. So to start, let's talk about minimum wage. And as many of you know, minimum wage has increased effective January 1st of this year. This isn't because of some new law or some new changes or anything. This is something that goes back to the Jerry Brown days when an act was passed that basically said, if inflation or the consumer price index exceeds a certain level, it will automatically trigger an increase in the minimum wage. And that is what we're seeing again this year, as we've seen the past couple years. So effective January 1st, the non-exempt hourly minimum wage is $16.90 per hour. So it's got about a 40-cent increase over the previous year, which, as you know, does add up as the hours rack up for employees. Now, the other thing to keep in mind too is that when the non-exempt hourly minimum wage goes up, this also has an effect on the exempt salary for your exempt employees. So I'm talking about your managers, your executives, anything like that. Anybody that's exempt on salary, exempt from overtime laws, exempt from meal and rest. Their yearly minimum salary has also increased to $70,304. So how do we come up with that number? Well, we took that $16.90 number, we multiply it by 40 hours per week, by 52 weeks a year, and then we doubled it to come up with 70,304. So if you have any managers or supervisors that are salaried, exempt, and they are not making that $70,304 amount, time to take a very quick look at them to see what you're going to do, whether you're going to increase their wages, their salary to hit that minimum amount, or possibly convert them back to non-exempt hourly status. And that is a thing. Just because you're a manager doesn't mean that you cannot be paid by the hour. As a matter of fact, in California, all employees default to non-exempt hourly unless you prove that they are exempt. So keep that in mind. And again, take a look at your payroll. Make sure that your non-exempt hourly employees are making that $16.90 minimum, and your exempt salary employees are making that $70,304 minimum as well. Now, for fast food workers, we know that was, very highly publicized in previous years that the minimum wage is $20 an hour. We are not seeing a change in that at this point. There is no, there's no saying that the advisory council won't meet later in the year and do an increase, but for the time being, that is staying at $20 per hour. And late last year, we also saw an increase in some in some employers in the healthcare field, that is staying the same again, ranges from $18.63 to $23 an hour, depending on which category you fall in. So for now, fast food and healthcare has not changed, but keep an eye on that. Mid-year we could see some adjustments to that. We do recommend, if you don't already do so, take a take a moment, sign up for our blog. We send out information whenever things like this change or whenever things are going to happen as well. Now, aside from the state minimum wage, we also have to keep in mind that there are local minimum wages and laws that could also change or be changing in the state. So last count we had, there was over 40 local ordinances that apply throughout the state of California. And a lot of time, these apply in large, metropolitan areas, maybe up here in Northern California, the Bay Area's got a lot of different ones. I know down in Southern California, you have a lot of different ones there. And we're not just talking about minimum wage either. It could also affect things like paid sick leave, whether it's how much you're supposed to give employees or how much they can accrue or carry over, what have you. So again, take a look at where your employees are working, where you're located. If you have remote employees too, take a look at where they're working from because there could be additional protections or additional requirements for them as well. One example I always give is if you have employees, say for instance, that go to different cities for, landscaping, you know, housekeeping, any other thing like that, or they go to different, they could go to different cities or different municipalities to perform the work. Make sure that you are aware of what the laws and guidance are in those municipalities because your employees should be paid according to where the work is performed. And if you're not sure where to find that information, we do have that bit.ly link there that'll take you to a document where we have compiled a lot of where we have compiled that information for you. So you could take a look to see what the different cities, different counties, whatever it is, what their minimum wage is, and whether there's any additional restrictions for paid sick leave or other leave protections. All right, we talked about wages. Now let's talk about the Equal Pay Act and what changed this year. We had Senate Bill 642 come about that actually amended the Equal Pay Act and made some changes to the existing law. So just a little refresher. I mean, what is the Equal Pay Act? Basically, the Equal Pay Act's goal is to prohibit you from paying someone less based on a protected category, and that's things like sex, race, ethnicity, those state and federally protected categories for performing similar work or substantially similar work. So, in other words, it's basically making it so that any kind of work-based decision is based on work, right? Any kind of decision that affects somebody's career, somebody's pay, somebody's promotions or whatever it is based on work and not on any of these protected categories. Some exceptions, of course, you can still make decisions based on seniority, merit, production, or what the state calls a bona fide factor, something that is not based on those protected categories. Well, there are some amendments for 2026. One of them has to do with the language in the act itself. Very simple change on this one. We basically amended the language where it's read another sex to read, or so it read another sex instead of opposite sex. So the original act used to read, members of the opposite sex. Now it reads another sex, and that is basically to recognize non-binary people in the state of California. The other thing that changed is that expanded the definition of wages. Wages to be what you get paid for the work performed. Well, now it includes other benefits as well, things like bonuses, stock options, that sort of thing. That is all included in wages now as well. The other big change was that the statute of limitations was extended for any kind of action related to violations of the Equal Pay Act. Initially, it was set at 2 years. It has been expanded to 3 years. There's a 3-year look back period for any violation. And keep in mind now with these amendments too, employees can recover up to 6 years of damages for continuing violations. In other words, if you do a look back on those 3 years and saw that this was possibly an existing situation, something that went back, then you can possibly go back up to 6 years to recover damages. So what that means for us as employers, of course, is that it's very important to hold on to our payroll records and any wage decisions for at least 6 years. Now, we already know that things like employee files, documents relating to raises or promotions, demotions, etc. Those are part of the employee files, and they should be kept while the employee is part of the company a little bit afterwards. Well, now we recommend that you hold on to any payroll records, whether it's your payroll register along with time cards, wage decisions, that sort of thing, for at least 6 years. That way, if you have to do a look back to see if there's any damages or defend your organization, you do have those records on hand. The other thing that Senate Bill 642 changed had to do with pay transparency. Now, as you guys remember from past labor law updates, if you're a part of them, California requires employers to provide their employees a pay scale for their position, or not just their employees, but also any applicant for the position. And the pay scale included, what the starting wage for that position was, and up to what the maximum that would be paid for that position was. And there was additional requirements for those employers that had 15 or more employees. You had to include this information in the job postings. And a lot of us, it was work, right? Because you had to go back and see what the true pay scale was. We had to include that. We had to see what the maximum was for the position. So you have to see what's the starting wage and what's the most we will ever pay. Well, the state kind of did us a solid on this one, actually. They simplified it a little bit. They changed the definition of pay scale now to just mean an estimate of what we expect to pay upon hire. So it's just a range for the starting pay is what we have to include now on that pay scale that we put on job postings, right? So it's just the starting salary range and not the entire range. And sometimes employers did shy away from that. They say, well, if it shows that we're going to start pay at $20 an hour and it's going to go all the way up to possibly 50, new hires are going to come in and demand that $50 right off the bat because they know that, we said we'll pay it. Well, now you can kind of shorten that down and just have that range for new hires. So it kind of simplifies it a little bit for us when it comes to those job postings. So that's a bit of a positive change for employers. We'll take any good information that we can. All right, next things we will discuss is the OBA, the One Big Beautiful Bill Act, which we will call OBA going forward because One Big Beautiful Bill sounds kind of silly. Sounds like something you hear in Rainbow Bright or My Little Pony or something. So let's talk about OBA. And the thing to keep in mind is that there are a lot of tax-related changes that come across from it, as well as some other changes, right? And again, the thing we heard a lot about was, no tax on overtime, no tax on tips. This is going to be great. Well, let's talk about what that really means. And when we first heard about it, a lot of us thought that, hey, that means that we're not going to take any taxes out of our overtime or out of our tips. We're going to take more home every week, right? Well, that's not necessarily what it is. What no tax on tips or overtime means is that will be a deduction that employees can take on their federal income tax. And keep in mind, this is only for qualified overtime compensation and qualified tips. And this is not permanent. This is not the law of the land till the end of time now. This only runs from the year 2025, so it was retroactive for the beginning of last year, through the 2028 tax year. Now let's talk a little more about what that means. And one thing to keep in mind too is I did mention that it started retroactively in 2025. So a lot of employers are thinking, well, wait a minute, we didn't know about this. What's that mean? What can we do? Are we going to get in trouble? The OBA did include a transition rule that allows employers to report an approximate amount for qualified overtime compensation and tips for employees. So you can make an approximation because honestly, we may not have been tracking it since the beginning of the year, right? This thing passed maybe halfway through the year or whatever it was. So, a lot of us were thinking, well, shoot, I didn't start tracking these things until, March or April. What do I do for January, February, March, for the first quarter, for the first half of the year? Well, you can make an approximation. There is an allowance for that in the act. So a little bit of grace, if you will. But going forward, those things should be tracked very meticulously. Now, let's talk a little bit more about this no tax on overtime thing and what that means. Basically, the first thing to keep in mind is that no tax on overtime doesn't apply to what you earn for the entire overtime period that you work, right? We know overtime is time and a half. Well, the no tax only applies to the half portion of time and a half. So if I'm making $20 an hour and I come in and work overtime, so for that whole day I work overtime, I'm getting paid $30 an hour. It's not no tax on the whole $30. It's only no tax on the $10 portion, on the half portion of the overtime compensation. And again, that no tax is only a deduction that can be taken during tax time. It's not something that that is just not deducted from my paycheck and I take more home. The other thing to keep in mind is it is only for federal qualified overtime. So as you know, under federal law, overtime is only any hours worked over 40 hours in the work week. In California, we also get overtime for any hours worked over 8 in the workday, but that doesn't necessarily count as overtime under federal law. So the half, the no tax on half, if you will, only applies to any hours worked over 40 hours in a work week. Keep in mind, it's only on federal taxes too. It doesn't apply to state taxes. So keep that in mind. When we talk about no tax on time and a half, it's only no tax on the half portion of it, and it is only on any overtime for hours worked over 40 in the work week. All right. So what should we do as employers? Well, if you work with a payroll provider, whether it's whatever company it is, make sure that you are partnering with them to make sure that they're tagging or coding that weekly overtime. What is going to qualify for that no tax deduction come income tax season? If you do it in-house, then it means, you have to do a little breakdown and see what are the hours that are worked over 40 in a work week. We have to tag those and make sure that we are listing them separately so employees know what their deduction will be come tax time. A little bit more homework. Sorry for those of you that do in-house payroll. I know it's not what you wanted to hear. Now, when it comes to no tax on tips, again, this is another deduction come tax season. This is not, something that won't be taxed at the time, paychecks are handed out. This is just a deduction that can be taken. And you might be thinking to yourself, well, that's great. I work as a HR professional and I'm going to ask my clients to start tipping me instead of paying me my full wages so it's not taxed. Well, that is not how it works, honestly. The IRS looked ahead of that loophole, if you will, and they gave us a list of what occupations are eligible for this deduction. So it's about 68 or 70, I believe, different occupations that can use this deduction. Anything from bartenders to water taxi operators and everything in between. So there is a link there, another bit.ly link. You could take a look there, and that should be able to give you some guidance to go to the IRS page where you can see if your occupation is one that qualifies for this deduction. So to wrap up on wage and hour, let's look to see what we're going to do to make sure we're compliant. The first one, of course, is make sure that we are paying those minimum wage amounts either for our non-exempt hourly employees or for our exempt salaried employees. Want to make sure we're paying at least those minimums. And this could include, if you have to include those non-exempt or increase those non-exempt employee wages, make sure that you document that, whether it's with a wage theft notice or some kind of documentation showing that that increase took place. Again, adjust those salaries for exempt employees as needed, or convert them back to non-exempt if you need to. And then make sure that we're auditing our equal pay practices to make sure we're complying with that Equal Pay Act. We do have a wage and hour audit pocket prevention package available in our store. If that's something you want to do to make sure you're auditing your information to make sure that you are compliant. So I see Juliana pop up. Do we have any outstanding questions out there? I know it was kind of busy over there.
We're pretty good for now. So
Okay.
yeah, keep your questions coming. And we're going to continue right along so we can get you out of here on time. So thank you very much, Eli, for covering all of that great information. Eli was all about the money. Now we are going to shift gears here and focus on some leave law and benefits updates. So specifically this year, where we have some updates are crime victims leave and also paid sick leave. And these are really important because we're going to want to go back to our employee handbooks and make sure that we're keeping those current with the changes in the laws. Another update in this area is some new restrictions on retention bonuses. So if you give a retention or a hiring bonus kind of with strings attached, so to speak, California now is generally prohibiting that. So we're going to unpack all of this for you, starting with crime victims leave. Now, I want to first give you just a little review on crime victims leave. This is a type of leave that we've actually had around for a very long time, but recently California's kind of taken another look at it, expanded it, and so we've seen some additional provisions in the past few years. And so I want to talk about what happened last year, and that will also help with what kind of some of those additional changes are for 2026 now. So first, it's important to know for all employers, regardless of size, you have to provide your employees a leave time that's protected. You can't discriminate or retaliate against them. Unpaid leave time off if they were a crime victim and they now need to go to court to seek some sort of relief for their safety or their child's safety. So one of the easiest examples that I give is, let's say you have an employee that was experiencing domestic violence and they now need to go to court to seek a restraining order. They would be able to take that protected time off to do that. Now, last year, they really expanded on the definition of who is a crime victim. It used to be limited to sexual assault, stalking, domestic violence. Now it's really any victim of a physical act of violence or threat of violence. And then the other thing that they did last year is they amended the government code. So these provisions used to be under the labor code. They moved them over to the government code. Which, how is that relevant for us? Basically, they just transferred enforcement authority to the Civil Rights Department. And so it's kind of giving us a clue that California is looking more closely on these protected leaves, and we may see the Civil Rights Department enforce these issues just like they do with harassment and discrimination. Now, even if you do not have any crime victims and that hasn't come up for your business, it's really important to know that there was a new notice requirement that came out last year. You might have recalled that that was published in July, and you are required to provide this notice. It's a published notice from the Civil Rights Department on basically crime victims' right. It's titled Survivors' Right to Time Off. And we have to provide this notice to all new employees upon hire. So you're going to want to make sure that you have that notice as part of your onboarding documents. You also have to actually distribute this notice annually to your employees. So it's not just something you can post in your workplace. You actually have to give it to your employees each year. So even if you did that last year, you're going to want to put it on your calendar again for this year. And then anytime someone makes a request for this notice, or if they inform you, I was a victim of a crime, or my family member was a victim of crime, you have to provide them this notice of crime victims' rights. Now, if you have 25 or more employees, last year there was also an expansion for the type of reasons that a crime victim could take leave. So if you're a slightly larger employer, in addition to seeking that court relief for their safety, they can also take time off for things like medical attention, victim services, mental health services, safety planning, relocation. Sometimes they need to get out of a dangerous situation, so they need to relocate to a new residence or get their child enrolled in a new school or providing care. And generally, these reasons, they would run at the same time as CFRA or FMLA leave. If the employee is eligible for that, those leaves run all at the same time. And they pretty much max out at up to 12 weeks. And in some cases, they have less time. So if it's their family member was the crime victim, usually it's up to 10 days of time off that they would get. So you want to make sure that your employee handbook tracks all this information because it's a lot to remember. And you want to have one place that you can go and refer to if you do have a crime victim that comes forward. All right, so let's talk about what happened this year with AB 406. Basically, we call this kind of some court-related cleanup or some things that they forgot to address last year. So there's a couple additional leave provisions that they now, again, have moved to the enforcement of the Civil Rights Department. And these apply to all employers, again. So even if you're a very small employer, it's a good idea to include this information in your employee handbook so that if someone comes to you, it'll be really clear whether they have a right to leave or not. But what it allows for is that for employees who are victims or whose family members are victims of certain specific crimes, typically it's serious felonies, not only can they go to court to seek a restraining order or something like that, but they can go to court and basically just keep tabs on their case. They can go and attend the judicial proceedings related to that crime. So any delinquency proceeding, post-arrest release decision, plea or sentencing, or any proceeding where the right of that person is at issue. So I think the easiest way to remember this is they have, again, the right to keep tabs on that court case and take time off to do that. All right, so a question that comes up is, can employees use accrued time, such as paid sick leave, to get paid during a covered crime victims leave. So could they turn it into a paid leave or a partially paid leave? Does anyone want to make a guess in the chat? And then we'll go over it. All right, so we're guessing yes, and you have guessed correctly. So yes, you're going to want to make sure that your policies are clear on this. Employees can actually use their vacation, PTO, mandatory paid sick leave if they are a crime victim and they need to take time off for one of these covered reasons. So they can turn it into a paid leave in that way. Now, another thing that was addressed this past year, this actually went into effect in October, is the law was changed to clarify that employees can also use accrued time, including their mandatory paid sick leave, for witness leave and also jury duty. So that's kind of a big clarification. And again, we're going to want to make sure our handbook is tracking this. So witness leave, what that refers to is if an employee receives a subpoena or court order to go testify in court. You know, sometimes they're not always a crime victim. It could be related to any court case where they maybe have relevant information and that they now are forced to go testify. They have protected time off for that. They can use their accrued time. Jury duty, so if they're called for jury duty, they get to use their paid sick leave. And a lot of employers do provide for some level of paid jury duty. Some employers choose to do that. So you might want to take another look at that policy in light of the fact that they can use their vacation or paid sick leave, and decide if you want to first provide some paid leave time, like, you know, for example, up to 3 days, and then they use their paid sick leave after that. Or you might decide going forward, we're just going to have them use their paid sick leave or vacation now that it's clear that they can do so. So make sure you're taking a look at your paid sick leave, crime victims leave, jury duty, and witness leave policies. I know San Bernardino provides a employee handbook template for you, and we can also help you out if you want a customized handbook that we work on. We can assist with that service. All right, the next bill that I'm going to talk to you about is AB 692, and this is the new restriction on retention bonuses. So I like to refer to this as stay or pay contracts. And I think the easiest way to understand it is with an example. So let's say that you hire an employee and you give them a $5,000 hiring bonus, but you say, if you fail to remain employed with us for at least a year, we can recoup that. We can take that back. As of January 1, 2026, California pretty much prohibits this practice. Same thing with tuition assistance payments. If you say, well, we'll pay for this training or for this course, but you have to remain employed with us for this long. Otherwise, you have to pay us back. Now, we really can't do that. We're prohibited from requiring any employer applicant either to pay us back or a third party like a training provider or a debt collector because the work relationship ends. Now, there are some very nuanced exceptions to this, where if you have a contract that meets a very long laundry list of requirements, sometimes you can get around this rule. But because it's so specific and detailed, we would recommend that you do consult legal counsel about your options and make sure that they draft that contract that's compliant with the law. When Governor Newsom signed this one, he asked for additional clarification with this law. So we're likely to see it amended maybe even this coming year, because it is pretty broad and still vague in certain areas. All right, so for our leave and benefits to do, make sure to update those leave of absence policies, as I mentioned, and make sure you have it on your list to distribute that crime victims notice on an annual basis. And then if you do have those retention or tuition assistance bonuses, make sure that you review them and adjust them going forward in 2026. All right, and the next section that we're going to cover is employee rights and protection. So we have some new immigration-related rights. So it's really kind of California's response to all of the increased enforcement that we've seen on a federal level. We're also going to talk about the Civil Rights Department's AI regulations. They refer to it as automated decision-making systems. That's a long mouthful of a word, but we're going to talk about that. How is California regulating employers' use of AI? And then we're going to close out with some information on personnel records, notice, and posting updates. So we have some brand new employee notices in 2026 and some deadlines that we're going to talk about for those. So first I want to go over SB 294. This is known as the Workplace Know Your Rights Act. And again, this was in response to the increased immigration enforcement that we've seen. And one concern that the California legislature seems to have is that we've heard of stories where people were arrested or detained at work, and then their family member might not have known about it, or their children might not have gotten picked up from school. And so what SB 294 does is it wants you as the employer to provide your employees an opportunity to name an emergency contact in the event they are arrested or detained at work. And then you will have an obligation to notify that emergency contact. And that's not just for immigration related issues. They could be arrested or detained for any reason. So the law is a little more broad. And your deadline to do this is by March 30th of 2026. So make sure that you put that on your calendar within the first few months. You're going to want to provide a sample form for your employees to fill out their emergency contact in the event that they're arrested or detained. So even if you have an emergency contact form on file, it's probably worth updating to make sure you're really clear that it's for that specific purpose. And then if someone doesn't want to designate an emergency contact, I would have them check a box noting that they declined to do so. So it's really clear that you gave them that opportunity. This is also now another form that needs to be provided to new hires at the time of onboarding. So going forward, this should be in your onboarding packet. Now, if someone is arrested or detained on the work site, you have an obligation to notify that designated contact. If it happened off-site, but it was occurring during work hours or when they were performing their job duties, maybe they were on a client site or at a conference, you must notify their emergency contact only if you have knowledge of it in that case. Because obviously you might not know that happened if it's off the work site. Now, penalties are steep if you fail to do that. That you fail to notify that emergency contact, that's $500 a day, and it maxes out at $10,000 per employee per violation. So it's pretty serious. Additionally, under this law, the Labor Commissioner published a brand new Workplace Know Your Rights notice. We posted about this on our blog. You can go to employers.org and access this notice. For this notice, it has rights about immigration-related rights, constitutional rights, rights when interacting with law enforcement. You need to distribute this notice to your employees by February 1, 2026. You have the rest of this month to do that. Annually thereafter, and also, again, to new hires, you're going to include that in your onboarding paperwork. So this is, again, you can do this at the same time as your crime victim notice. You can put the Workplace Know Your Rights Act notice when you're sending that out each year annually, but you're going to want to get in the habit now of doing that. And they said that you can send it out via personally, directly, email, as long as you can guarantee that it's going to get into the employee within one business day. All right, so this big fancy term, automated decision-making systems. Recently, our Civil Rights Department has regulated this. And what that refers to is basically any computational process that makes a decision or facilitates human decision-making through AI, artificial intelligence, like ChatGPT, right, Copilot, machine learning, statistics, or other data processing techniques. So you might see this big term, automated decision-making system. Just know it's kind of a larger umbrella and AI falls under that. So California has now regulated that if you are using these systems, AI, to help make employment decisions, right? If you're using it to screen resumes, if you're using it to select who is going to be selected for a layoff or who you might want to promote if you put that data into the AI and the AI helps you make that decision, California has regulated that. So let's talk about what you need to be aware of. So these regulations went in effect on October 1, and what they are really aimed at is if potential discrimination happens when you're using those AI tools. So right now there is a lawsuit. It's the Workday case where the allegation is that these resume screening AI tools were screening out older applicants, which is a protected class. So even if you as the employer, you're not intending to do that, what this is saying is you can still be liable for that. So basically you're using AI tools at your own risk. If they end up discriminating against a certain protected group, someone could bring a claim under FEHA for that. So keep that in mind. We do also have to retain those records if we are using AI, not just for general business, but if we're using it to inform our employment decisions. Again, who we're hiring, who we're promoting, disciplining. If we're using it for that purpose, we have to hold on to those records 4 years from the date we created them or the personnel action involved, when we ultimately made the hiring decision, for example, whichever comes later. So you're going to want to get in the habit of doing that if you are using AI. We would also recommend that you have an AI policy in your handbook if you are using it at all, even for business purposes. just so it's really clear with your employees, what are the permitted uses? What are the restrictions? You might love AI and you want to take full advantage, or you might say, we're not going to use it for certain purposes. And you might want to remind people about things like confidentiality and accuracy. So we would really recommend creating a sample AI policy in your handbook. All right, and the next one is SB 513. Now, this has to do with personnel record requests. So you may have gotten a request from an employee or former employee, and they might say, I want to see my personnel record. So I want to give you a little refresher on what the law requires, and then we'll talk about what were the changes for 2026. So as a reminder, we are required to provide both current and former employees and any representatives, that could be a union rep or an attorney, the right to inspect and receive a copy of someone's personnel records if they make a request for it. So if the employee wants to see their personnel records, we have to produce a copy of that for them. And within those personnel records, it's going to need to include information about the employee's performance and any grievance, meaning complaint concerning the employee. And that is due within 30 calendar days from the request. If we fail to produce those records within 30 calendar days, then there's a $750 fine. And if they sue us, they can also get their attorney's fees and costs. There's actually a very similar provision for payroll records that you have to provide them within 21 calendar days. So it's a little bit shorter of a window for payroll records. Now, effective January 1 of this year, you must also include education and training records. So anytime you are training your employees, you're going to have to now document the name of your employee, the name of the training provider. So if you brought in a third party to do the training, like CEA came and did harassment prevention training, you would want to note that, right? The duration, meaning the length, how long was the training, and the date of the training. The core competencies, so what was the training about, right? Any special skills in equipment or software. And then if they got a certification or qualification, we're going to also include that information. So it's not really difficult, but it is administratively burdensome now. And education and training records, that term is not defined in the law. So we'd recommend you err on the side of caution. If you're doing onboarding training, harassment prevention training, training through an LMS, a learning management system, we would recommend that you're now documenting that information and putting it into the employee's personnel file. All right, and then lastly, just a reminder on labor law posters and notices. If you do have one of those all-in-one state and federal postings on your wall to include all of those required notices, some of them have been updated. So if you have a 2025 version, it's important to get a 2026 version. So we have Cal OSHA, Safety and Health Protection on the Job in both English and Spanish. That was updated in July. The California minimum wage order, because minimum wage went up, obviously that minimum wage poster changed. Also, if you are in an area that has local minimum wage requirements, you're going to want to go to those government websites and make sure you print the local minimum wage order and put it up in your workplace. Also, the paid sick leave healthy workplaces poster was updated based on some of those changes that we talked about. And then the EEOC Know Your Rights poster has not been updated, but it is marked as undergoing revision. So we may see that poster change later in the year. And then we already talked about these notices, but just again, as a refresher, the Civil Rights Department Crime Victims Notice and the Labor Commissioner's Workplace Notice of Rights. As we mentioned, you're going to want to get in the habit of actually distributing those notices to your employees on an annual basis. And if you do need that 2026 labor law poster, we do have it available for purchase on our store at employers.org. All right, so wrapping up here, make sure that you prepare that emergency contact form. You have until March 30th to complete that. And then ensure human review of AI processes and that you're following record retention if you're using it for employment purposes. Make sure that you are in compliance with those training and education record keeping requirements. And then watch out for any updated notices and posters going forward. A really great way to stay tuned with HR news and updates is to follow CEA's blog at employers.org. And also call into us. I know we had to get through this material a little quicker today, given the delay at the beginning, but please call into us with any follow-up questions that you might have on the hotline. We are happy to assist you and available Monday through Friday from 8 to 5. Again, I want to give a big thanks to the San Bernardino Workforce Development Board for partnering with us and sponsoring this event today. Again, there is the hotline number for you there, 877-282-3763. And then also we have some information for you here if you're interested in joining us as a CEA member and getting access to all of our sample forms and resources. And we also have a little checklist for you if you just needed some additional assistance with, okay, what do I need to do at the start of the year? So we have bit.ly links for you to get access to the labor law poster, information on updating your employee handbook, and then also completing harassment prevention training, which is due every 2 years. And with that, I will turn it back over to Carmela and Anna to help close us out today.
Sure. Thank you so much to Eli and Juliana for, I know that was rapid fire, but you still got us out at basically 11:01, right on time. So we appreciate you guys being so astute with your presentation. Thank you all for such amazing engagement in the chat and in the Q&A. I love all these insightful questions. I just want to give one more reminder that you do have that complimentary HR hotline provided by San Bernardino Workforce Development Board. So please utilize that resource. That is going to be included. If you did not notate that number, it's going to be included in that PDF that, again, I will be sending to you all as soon as we wrap up here on Zoom. I can pull that email report. So I can give you guys a list of some of the resources that we shared today. I'll include the link to this survey that you see on the screen, as well as a link to that YouTube channel where, again, I know we had to go at a quicker pace to honor your time today, but in a few days, you'll be able to access this recording to use with